We are live.
All right, good afternoon and welcome to the Subcommittee on Family Law and Juvenile Law. We are going to have a very brief subcommittee meeting today. Apologies for the lateness because we have some technical difficulties. But the bill we are going to take a look at this afternoon is HB 639, and that is a bill that deals now with new grounds for divorce. And so I think what I'd like to do is just make sure the committee is aware of what those new grounds are. And I think probably one of the folks that would be best able to do that for us would be Michelle Smith. If you don't mind, Michelle, just telling us sort of what this bill does, and we'll go from there and ask a few questions afterwards.
Great. Well, I would defer to Madam Chair Atterbury, but if she wants me to do it, I would be happy to.
It's up to you, Chair. Would you prefer?
Thank you. Yes, Michelle, go right ahead.
Okay, great. So very simply, it creates a streamlined version of grounds for divorce. Sorry about my fan. What the new grounds will be, some are old, some are new. The new ones are a 6-month separation where the parties have been living separate and apart, but they could still be living under the same roof as long as they're living separate lives. The other new ground is irreconcilable differences, and that's just what it sounds like, that they're no longer getting along, and that's on the claim of one of the parties. So one party can simply file for divorce asserting irreconcilable differences. And then the grounds that are left over from the old statute are the permanent legal incapacity of one party who lacks the legal capacity to make decisions. And then our favorite, the mutual consent, where the parties have a written agreement that they have both signed and that deals with all of the issues related to children, support, and property division. So those would be the 4 grounds.
Okay, thank you very much. And
I just have one thing.
Sure, that's fine.
Smith just said. So as I sort of worked through this, I was a little concerned, what if you couldn't prove irreconcilable differences? Like, would that get complicated? But in working with Ms. Smith and Ms. Ruth, a group of people, what we realized is that if somebody couldn't prove irreconcilable differences, like one person said, really, we can work it out, and the other one said you couldn't, then you would just have to wait for the 6-month separation. So I think it accounts for everybody in every situation. It would cover people.
And do we have any examples of what we would consider irreconcilable differences?
You know what we decided was like pornography. We couldn't define it, but we'd know it when we saw it.
Okay.
For the non-lawyers, that's like lawyer joke, but no, I think, and Madam Chair can certainly chime in here, but I think what we decided is we didn't want to define it too carefully because we were concerned we'd limit it. And we kind of wanted maybe the case law to flesh it out if it passes. But I think, somebody's having an affair, it really could even go to the gender transition bill that we heard in the committee last week. Somebody's transitioning to another gender and the other person feels like that's impossible in the relationship. It could be everything from that to it just isn't working out anymore. If the other spouse wants to contest it, then I think you would, if the judge said, nope, I don't believe it's irreconcilable differences, then you'd switch over to them. You'd have to amend your complaint to the 6-month separation. But
are there examples, from other states that maybe you've seen, other than that, or are those sort of kind of the real gamut of what examples look like?
So if I could jump in on that, one statute that we looked at very carefully is from California. And what the California statute, I may have it on I may be able to share it if that's possible. I don't know if I still have it on my desktop. Happy to do it if I can, but I can say it to you. I know I'm a much more visual person, but the way California deals with it goes like a step further than what we have in this bill. And it's also based on irreconcilable differences, that same phrase, which we see appearing in most of the other states that have this type of grounds. And then they have a comma, irreconcilable differences, comma, which have caused the irremediable breakdown of the marriage. And then it goes on one step further to define irreconcilable differences as those grounds which are determined by the court to be substantial reasons for not continuing the marriage and which make it appear that the marriage should be dissolved. Now, we talked a lot about that in our work group about whether we wanted to have that language. I don't think anyone is opposed to the language, but we wanted to introduce a bill in concert with the chair's guidelines and guidance to us that was as simple as possible. So we didn't want to make it overly complicated by adding this language, although we're not opposed to it. What we said was irreconcilable differences upon which the marriage should be terminated. So we did keep a little of that language so that I think that case law would come in from Maryland and say that a judge has to actually decide that the marriage should be terminated. It's not like we're just saying one party can simply wake up with no explanation, go down to the courthouse, say, I'm done, I'm divorced, and poof, it happens without the other party having a say in the matter, or a judge sort of presiding over the procedure to make sure that things are still fair and equitable as they always have been in our state.
Okay, Delegate Shetty, you look like you have a question.
I do. Thank you, Madam Chair, and thank you, Chair Atterbury, for bringing this bill. I think it makes a lot of sense for us to work towards modernizing our marriage and divorce laws here in Maryland. And I think this bill does a great job of going a very long way towards doing that. So thank you for bringing it. My question is, I guess, and I don't know if this might just be easier for me to wrap my head around if I had like a side-by-side or some sort of like thing here, but I'm just wondering if somebody could walk through how this changes waiting periods under each of these new grounds, and then also what type of information is required to be worked out in advance of the petition or the filing. Because I guess I'm somewhat familiar with the mutual consent option, and it seems like basically everything has to be worked out at that point and between both parties, and then they come to the table and say, judge, just sign off, basically. But what is required to be done by one or both parties, and what I know with mutual consent, for example, there needs to be like custody plans essentially presented and in place. Is there similar requirements ahead of any of the other ones in the event that there are children? Okay.
No. So what, as it stands now, you can get an uncontested divorce using any of the grounds available, but you have that 1 year waiting period now before you can file on the separation grounds. You have a 1 year waiting period for desertion or constructive desertion. If you want to have no waiting period right now, you have the fault-based grounds of adultery or cruelty of treatment, or you have the mutual consent. And the mutual consent was a great advancement in our law, but you have to have everything done in advance. You have to submit a voluntary separation agreement that resolves all of the issues of the marriage, property, alimony, even if you have nothing. If you were married for 4 hours and then you decide it was a mistake, you have to sign a separation agreement that says we have nothing and want nothing, and we're waiving alimony forever and all time. So that's the ground that you have to do something in advance. But in every other instance in current law, and if we passed this law, that would stay the same. Mutual consent, you'd have to have the separation agreement, and it's an uncontested divorce. But under irreconcilable differences, you don't have to have anything in advance. You file, and they file an answer. Many cases then settle after the filing, and then you could shift it over to an uncontested hearing, but you don't have to have the written and signed separation agreement like you do under mutual grounds to divorce. But you don't have to have agreed to anything. The court would still be responsible for resolving marital property, custody, child support, alimony under irreconcilable differences or under the 6-month separation, just like it is now. So that's not changing. All it's doing is updating all those out-of-date grounds for divorce, getting rid of fault-based grounds for divorce, although that can still be a consideration when a court is deciding about marital property, for example, or if they think that behavior such as adultery or cruelty of treatment is affecting the children, it might affect their assessment for custody purposes. It's just not a ground. And I think what people don't get, and litigants too, because I talk to hundreds of people every year who don't get it, usually it's not the ground that's in dispute. The ground for divorce is a sort of a negotiating tactic and a strategic tactic that is used about when and how to get into court. And, and there are people whose feelings are very, very hurt and who are upset and want to use a fault-based ground. But 9 times out of 10, that's not what the fight in court is about. It's not about whether it should be adultery or 1-year separation. It's about what should we do about custody, child support, alimony, marital property. And so, this doesn't change those fundamental pieces, that really the ground is not the issue in these cases. It's everything else. This just simplifies the grounds and helps people get help faster by shortening the amount of time you have to wait.
And if I can just add to what Ms. Ruth just said, at House of Ruth, we often file on either excessively vicious conduct or cruelty of treatment because our clients, there's always been domestic violence. And so we file immediately. It doesn't mean that everything has to be resolved. In our cases, it's almost never resolved. They tend to settle eventually, but they're not settled walking into court. So it's just a slightly different strategy or procedure.
Okay. Any other questions from the committee? Okay. Chair Atterbury, do you have anything that you'd like to add?
Madam Chair, no, the folks have done a wonderful job, so I appreciate all the work that they have done on the issue. I will just reiterate, I think I said it in the hearing, that the family law section of the bar strongly supports the legislation. And I just think it's really important for us to evolve with our divorce statute here in the state of Maryland.
Okay.
And I'll just reiterate too, I think this bill would have the biggest effect on the citizens of Maryland of pretty much any bill that that the Women's Law Center is working on this year, because simplifying our divorce statute would just be life-changing for a lot of people. And we talked to, on our family law hotline, we talked to 6,000 self-represented litigants a year, and I dream of the day where I wouldn't have to have these extensive conversations about, you don't qualify for that ground, maybe you can qualify for that ground, and then you do get the people who say, well, he's mean to me, so can I use the cruelty of treatment ground? He's just a mean guy, but he's never hit me. It's not it's not what we would necessarily think of as cruelty of treatment, but they're hoping that they can jam those facts into that ground so they can go faster to end something that they both maybe want to end. So I just, I really, really encourage you all to vote favorably on this bill. I just think it would be really a fabulous advancement in our law.
Okay. And I believe there's no opposition to this bill. I did not see any testimony or anything else, and we did not hear anybody testify against it. Is that correct, Chair Atterbury? Okay. All right. So do we have a motion to move this bill out of subcommittee and to the full vote of the Judiciary Committee?
Move favorable.
I'll second.
Thank you. We've got a favorable second. So let's go ahead and Dylan, I think this is where I need your help. Do we need to do a roll call vote? I think we probably do. I'll just go ahead and do it anyway.
Yes, go for it.
Okay.
We need 4 votes to pass the bill.
Okay, thank you so much. All right, so I'll start with Delegate Lopez.
Yes.
Okay, Delegate Howe.
Yes.
Okay, Delegate Shetty.
Yes.
Delegate Williams.
Yes.
Delegate Munez,
Yes.
Delegate Cham,
Yes.
and myself is a yes, and your bill is voted favorably out of the subcommittee.
Thank you so much.
All
Thank
right,
you.
no problem.
Thank you, Chair Atterbury, as well.
Yes,
I
thank you.
really, really appreciate it.
Yes, I didn't make it clear that I'm here for the Family and Juvenile Law Section Council of the Maryland State Bar Association, and we are thrilled with that vote. This is our biggest piece of legislation. We fully support it, strongly support it. So thank you very much.
All right, thank you, and we'll see you on the floor shortly. Chair Atterbury, thank you. All right, so we're going to move to our next bill, which is HB 823. And we should pull into the waiting room. There probably is Gray Barton who's in there. Is there anybody else in there? Yeah. Okay.
Mr. Barton is in, nobody else in the waiting room as of now.
Okay, perfect. All right. Okay. So what I'd like to do is go ahead and let's just talk about 823 really quickly. And that is the bill that's dealing with expanding the truancy courts, okay? And it's titled Truancy Reduction Pilot Program Expansion. So what I'd like to do maybe is let's have Ms. Kaplan maybe, and Mr. Barton, if you could just kind of explain what this bill does for the committee.
Sure. Gray Barton, I am the Director for the Office of Problem Solving Courts, overseeing all the problem solving courts for the Maryland Judiciary. Thank you, Subcommittee Chair. Real briefly, just give you a few talking points. This bill was put forward by the Judiciary, the goals of recognizing that 18 years after the law was first enacted, truancy courts are not a pilot program any longer. They are fully recognized problem solving courts. And so this bill would remove the pilot portion of the name from the court's name. It also streamlines the process for establishing a truancy court by repealing the requirement for legislative action before a truancy court can be established, and instead placing the responsibility on the courts as is for other problem solving courts. For example, today I just received a draft of a truancy court plan, and that's part of the process for any new problem solving court. It comes to the Judiciary, it goes all the way up to the Chief Judge for them to approve a new problem solving court, and that was for Frederick County for a truancy court. And so they would have to have legislation changed for them to even start a truancy court. And it also emphasizes and strengthens the rehabilitative focus of the truancy courts by changing the name of truancy reduction and changing the name to Truancy Reduction and School Reengagement Program, establishing a clear rehabilitative purposes for the program and expanding the dispositional tools available to the court. Real briefly, the three things that I want to say that the bill does not do. The bill does not supplant the role of the schools as a front line to addressing truancy in any way. The truancy petition is filed within the juvenile court after the school system has tried to address the truancy court, the truancy without court involvement. And we fully support all types of truancy behavior programs, be it in the community, be it obviously school-based, and then ultimately leading up to the courts. The bill also does not seek to criminalize truancy at all. Truancy courts cases are civil proceedings and do not result in any of the sanctions that may occur in the result of criminal proceedings. The goal of the truancy court is not to punish the child or the family. It is to find out why the child is not attending school and identify and implement ways of addressing those causes. And finally, the bill does not prevent any approach to truancy prevention and school engagement, including other approaches that involve courts or judicial personnel. As I stated earlier, is that we're very open to, community-based truancy programs as well as school-based programs.
Okay. All right. Thank you very much. And Ms. Kaplan, did you want to add anything? Because
No,
okay.
I think you summarized it beautifully.
Okay, perfect. And I do know we have some opposition, and that is from the Office of the Public Defender. And so, Ms. Williams, would you like to give your position on this?
Yes, and thank you very much for allowing us to participate in this work group. So we did submit an original statement for the hearing. I did provide an updated statement. I wasn't sure if it was received prior to today, but there was some research cited in there. We have concerns about the expansion of the court version of the truancy program. We do not have a problem with any expansion of the community-based truancy programs. And so I just want to make sure that that distinction is clear in our position. We do have active involvement and have fully supported the community-based truancy programs. In fact, I myself volunteered for many years with not only Truancy Court, but Teen Court, which are outside of the court system. And there's a reason that we support those models as opposed to expanding the model within the court system. One of the main reasons is that the evidence doesn't support that that is actually effective in reducing absenteeism. The report that was issued back in 2011, which compared and analyzed all three of the current programs in Maryland, looked at the efficacy of all of those programs. And what they found was that expanding the two community-based programs should have been a recommendation based on, or excuse me, all of the programs needed more evidence to support their effectiveness, but at a minimum, there was a suggestion that the two community-based programs should be expanded as opposed to the court-based program, which was the least effective. There is tons of research and data across the country that shows that once you start bringing children into the court system, it actually results in worse outcomes for that child. And it also can lead to further deepening involvement within the juvenile justice system. I understand Mr. Barton says that this is not a criminalization of youth. There's no intent to criminalize them, but when you are authorizing the Department of Juvenile Services to get involved in the capacity where a petition is filed, the court is then setting an adjudication, which is the same thing as a trial in a juvenile court. And there are sanctions imposed as a result of a court order. The question is what happens if there's a violation of that court order, if the child does not attend counseling, if the child does not, participate in the things that are ordered by the court. That then can be a violation that can cause further harm to the child, including detainment or incarceration if they're placed on probation. And so we have concerns about that expansion. We have concerns about just bringing more kids into the juvenile justice system when we're currently trying to eliminate children that don't need to be in the juvenile justice system. We just passed, last year, this House passed the Juvenile Justice Reform Council bill, which one of the things was to make sure that these types of cases aren't in the court system, but that we handle them in a way that's in the community. And so I understand that's a bit of a lengthy explanation, but that is the basis for our opposition here today. But overall, we are in support of truancy programs, just not through the court system.
Okay. All right. Does anyone have any questions? And if not, I think I'll start then.
Chair Crutchfield, I apologize. I was trying to get to the raised hand
No
function.
problem.
Couldn't find it. I apologize. Okay, yes. Ms. Williams, thank you very much for what you just shared. I was taking some notes here, making the comparison between the court expansion component in the bill. You mentioned that it research states that it's least effective versus the community-based program as far as involvement with truancy. What are some expansions regarding the community-based component that you can share with us?
Sure. So there are two programs that currently run in Maryland. One of them is through the University of Baltimore Law School. I believe that's called B-Smart. That's the one where our agency has actually been involved with. That program has actually been fairly successful in terms of being able to provide direct services to the youth. It's in the school system where they meet with the child within the school system, they meet with the family, but they specifically focus on what is the problem that's causing the truancy, whether it's homelessness, whether it's lack of sleep or lack of proper food, and they're just not getting their needs, and so they go out and feel like they have to get another job. There's a number of reasons that are involved in truancy, and when you start looking at ways that can actually address the family problems, the root of the problems, that is where it has been successful. And so there's social workers that can get involved, there are school counselors that can get involved, those do not require court involvement. So we would ask for expansion of those resources, such as social workers and community counselor or school counselors. Those are things that are actually going to help address the root of the problem. And transportation is a huge one. I know that free transportation is provided, but that oftentimes is a barrier. I don't know if any of you've ridden the public transportation in Maryland or in Baltimore City, but it is not always reliable. And so there's a number of reasons that can contribute. But a lot of it does stem with family poverty issues that can be addressed through social work or community counseling, or school-based counseling.
Thank you very much, Ms. Williams.
Any other questions from the committee? Okay, so let me just ask a couple of questions, Ms. Williams. So let me make sure I'm understanding what you're saying, okay? I know that when a petition is filed, and it's my understanding that the way the truancy courts currently work, and first of all, let me take a step back. This is really enabling legislation. I mean, allowing for additional courts to be set up in other counties, because I know there's only a few counties where this is currently occurring. For example, in my county, Montgomery County, we do not have a truancy court, but we do have a program through our state's attorney's office that deals with truancy issues, okay? So, I mean, from what I'm understanding, as a young person goes through this process, it starts with the specific Board of Education of that county, who has some kind of programs and things they do. And then when a child really comes at a point where they really are, and I don't know how many times this is, if this is 10 days out of the year, where they don't have a excused absence, is when they're usually considered to be a truant. I mean, that's when the parent comes in and there's involvement there and they sit down, et cetera, and they find out maybe they cannot do anything with the regular resources through that particular Board of Education. So that is when a petition is filed with the court through the Board of Education. Now, the child, is my understanding, it's not a petition for delinquency. So they're not criminalized in any way. It's my understanding this is more of a attempt to try to make sure that child stays in school through other means without criminalizing them. Now, I understand that you're saying, well, just the involvement of being in court can create trauma, which I totally get and understand, but I'm trying to understand, because there are also resources that are brought in at that same time when that child, when that petition is made, that child goes to the court. Yes, there is a judge there that indicates what needs to happen next, or how they can work with the family in order to get the services that are needed. So I guess I'm trying to understand if there's a way that you can maybe understand how we can maybe marry up the services so that they are more robust in that truancy court, and allow and maybe give what you're thinking of that the child should get. Now, again, I may be wrong, but it was always my understanding they are not delinquent. So this is not criminalizing them, but go ahead and kind of give me your thoughts.
So I just want to, yes, and I know it is a bit of a confusing concept, but when we talk about not criminalizing, the criminal court system is for adults throughout in Maryland. And when we talk
Correct.
about the delinquency juvenile court, that is essentially the equivalent on a juvenile level. So
Yes.
While we're not criminalizing them in the sense that it's an adult criminal court proceeding,
Mm-hmm.
it is still the equivalent on a juvenile level. And the fact that they are still subject to things such as incarceration through detainment, being handcuffed, being placed on probation. These are all consequences that can be imposed in the juvenile court system. And so what I'm recommending is the expansion of the external programs that already exist. And as you mentioned, yes, there are only a few counties that have the court system truancy program. And that, I believe, was started as a pilot, the truancy reduction pilot program. And I believe that is what this bill is trying to do, is expand that pilot program, which started the court system in only a couple of counties. However, what I'm saying is there are two other programs that have been very successful outside of the court system. The one was, I mentioned, Be Smart, and then the other one, I think it's just a Truancy Court program. But I would refer you to it's a 2011 report, which is very helpful. It's actually authored by the Administrative Office of the Courts and the State Justice Institute that put together this report on all three of those programs. And I did cite it in the updated statement that I provided. And so when you're talking about bringing a child into the court system, they are still being subjected to court orders where if they violate, they are being treated as a delinquent child. And if they are found adjudicated and facts sustained that they did violate their truancy petition, they are considered a delinquent child. And that, that is a record that can stay with them until they're 21 years of age. So there's a host of collateral consequences that go along with it. And so there's a reason for diversion. There's a reason for alternative methods outside of the court system, because it can have far greater implications than just addressing the root problem, which can be resolved through the community.
Okay, so I guess what I'm concerned about is that, first of all, the children are not considered delinquent when they're coming through this avenue. Okay, have there been instances where children have been determined to be delinquent based on truancy?
So yes, it can be considered a part of their services, their order that they're required to participate in, or they're not supposed to violate. Truancy is certainly something that they can be found delinquent for. This bill does expand the involvement of the Department of Juvenile Services and the court system. So it does.
But it's only my understanding through SINA, is that how you pronounce it? SINA, the Court in Need of Child Assistance. That's the way DJS is brought into this. No. Okay.
No. Oh, sorry.
Okay.
Does somebody else want to? So there is a distinction between SINA and SIN. So child in need of assistance, those are children who are essentially coming into the court system through the Department of Social Services due to some type of neglect or abuse, whereas a child in need of services is considered a delinquent child through the Department of Juvenile Services. So it's my understanding this bill is taking the avenue through the child in need of services, the delinquency avenue.
Okay. Ms. Kaplan, did you want to add something?
Thank you. So to clarify, this bill does not implicate the delinquency system. It does allow for a referral to the SIN system. That's a child in need of supervision, because the code does define a child in need of supervision, including as someone who doesn't attend school regularly. The goal of the language around that was to permit the services that are available to a child through the SINs system to be made available to children. We know that in this state, there's often bifurcation of services. The Department of Human Resources, the Departments of Social Services have certain services, DGS has certain services, mental health has certain services. The goal of having that language in there, and it's permissible, not mandatory, was to make sure any services accessible through the child in need of supervision services would be available to children in this program. But that's not the most important part. What is most important to say is there's no connection between this, aside from that it's the same judges and magistrates, between this and delinquency. You can't be a delinquent because you don't attend school. That's not one of the elements in Title 3-8A for delinquency, and it's not part of the rules. It simply are two separate systems. If a child doesn't comply with this, the courts use resources within their program, within the Truancy Court program, to address those. They do not use locking a child up. That's just simply not available to the courts under this program. I also wanted to point out about the report, when we can send you that report if you have trouble accessing it online. But I want to point out that that particular report actually had many wonderful things to say about the truancy courts. And you can see that, I think it's on page 75. I'll get you that exact location. Pages 74 to 95 of the report, and they summarize that the Truancy Reduction Pilot Program is an innovative approach to organizational collaborative, accountability, and service provisions, which aligns with recommended practices found in national literature concerning truancy intervention. They talk about the small sample because we don't have enough programs. Again, part of what this bill will do is help us to hopefully establish more more programs, but they simply did not criticize the Truancy Court and find it an inappropriate program. To the contrary, as I said, they found it to be an innovative and appropriate response. I also wanted to talk about the services that can be ordered. In fact, there is more access to services through the Truancy Court than there is through the University of Baltimore program, because the Truancy Courts are connected with those service providers. The judge who has a relationship that is different than the one, and I monitored the University of Baltimore program. I think it's a wonderful program. The judiciary funds it, the office that I'm part of. I'm the juvenile law manager. I'm in the family division. I deal with juvenile related issues, which is why this is under my bailiwick. We fund the program at UB. I personally think it's a pretty awesome program, but I'll tell you, they don't have the connections to services that a juvenile court does, by the virtue of the fact that, as you all know, juvenile courts have the ability, juvenile court judges and magistrates, to bring together at one table people who control the budgets and have that ability to work with people in a way that agencies just can't do in the same way. So the court has its ability to, and many counties do that, refer cases over to the mental health program for evaluations and drug and substance use evaluations, to bring in the schools to talk about what other programs they have available. One of the things you saw that we've done in this bill is give the court, with the approval and consent of the education, the Board of Education, to refer those kids to alternative forms of schooling so that GED and other alternative forms are available to them. That's one of the issues that some truancy courts have talked about. These kids don't want to go back to regular school. We need a method of engaging them in education. This bill and the expansions in it give the court the ability to make those referrals. That's a piece of court role. There's no limitation on services. It's an increase in services through these kinds of programs. I think that you will find that if this bill went through, that we would be able to report back in a year about increase in services and collaboration that we don't have in as many counties as we could. Thank you.
Thank you very much. Delegate Shetty, did you have a question? Okay.
Thank you, Madam Chair. And thank you for bringing this before our subcommittee to discuss. I really appreciate it. I just have a question, and I don't know if it's better for Ms. Williams or for our council, but I'm looking at the language on page 5, lines 14 through 20. And I just have a question about what specifically lines 16 and 17 mean. So 14 begins with a criminal defendant under this subtitle charged with the violation of section 7301 of the ed article is subject to number one.
That's language that refers to a parent. It's language in the criminal code that allows someone who interferes with a child to going to school, the adult, to have certain sanctions against them. It is not about the child's behavior or action. So very few cases of that. I think Mr. Barton might have some more data on that. There aren't that many cases on that. That's what that's about. It's about those circumstances. Again, so
the criminal defendant in reference is not referring to a child. It is referring to the parent.
It's the person who would be responsible for getting that child to school, parent, guardian, or someone who in other ways, an adult who interferes with the ability of that person to go to school. It is not about the child who
is that defined in the education article 7301.
If you look at, and I'll try to pull that up for you in a minute and be able to read that to you if you give me a second and go on to others, I'll have that language, but it's clear from the education article. That's what it's talking about. If you give me a minute, I'll get that language for you.
Okay.
Well, yeah, I'm looking at 7301 and just curious if that's clear there. I don't know if our council or Crystal wanted to mention anything. Thank you, Madam Chair.
Okay.
Yes, I can help, Delegate, if you'd like, to provide the information on the education article 730 E2. It's a crime for a person who has legal custody or care and control of a child who's 5 years old or older and under 16 to fail to see that the child attends school. So, and that's a misdemeanor, and there are specified penalties. And so one thing to note about this bill and where there are truancy courts is that if a parent is charged with that crime and there is a truancy program or court in place, the court has the option of marking that charge stet on the condition that the defendant participates in the truancy court program.
That's super helpful. Thank you.
Yes, thank you. Any other questions from the subcommittee? Okay, seeing none. there was mention a couple of times, I think, Ms. Williams, you mentioned a specific report, as well as Ms. Kaplan. I think I'd like for us to get that report. And also, council, if you could maybe send us a, just maybe a short paragraph to just describe the education article, section 7-301. And I'd like to maybe hold this bill until our next meeting, once we have that additional information. And is there any other information that the committee believes that they need? Any other questions? Okay, but I'd like to do that. Sure, Ms. Williams, go ahead.
If I may ask a question of Ms. Kaplan, in terms of the, there may be some clarification needed in terms of what a judge is authorized to do. Do you mind if I get clarification on that from Ms. Kaplan in terms of the county procedures?
Let's do this. Maybe you and Ms. Kaplan can speak off camera at a, and let us go ahead and try to get this information, and then we can come back and maybe you can present the question and we can, at least get a little bit more information. Okay.
Absolutely.
So what we'll do is we'll table this bill until our next meeting. And at that time, we'll have additional information and then we can take a further look at everything. But I do appreciate everybody being here. Again, I believe we'll try to have another meeting this week sometime. So please be on the lookout and we'll send out the details of that meeting. But for now, we will go ahead and table it and we will end this subcommittee meeting. So I'm Delegate Charlotte Crutchfield, Chair of the Family Law and Juvenile Law Subcommittee, and we are going to now sign off. So I will see everybody later. Thank you so much.